Your property is in violation of community standards. You have 14 days to comply, or the association will take action." She said it the way someone reads from a card they have memorized but never questioned. Standing at the edge of my grandfather's drive in a blazer that had no business being on a gravel road in October, holding a clipboard against her chest like a shield, I was still in the truck. I had been back from Kandahar for 11 days, and the jet lag had not fully released me, and I was looking at the place where the barn had stood for 61 years, and where now there was nothing but a rectangle of pale, pressed earth and a few scattered boards the crew had not bothered to haul away. They had no idea. That is the part I want you to understand before anything else. The woman on my drive, Sandra Pruitt, president of the Millhaven Estates Homeowners Association, had no idea that the land she was standing on, the road she had driven in on, the half-acre of cleared ground where the barn had stood, and the timber easement running along the western fence line all trace back to a single recorded deed, filed in Calhoun County in 1961, that named my grandfather, Eldon Ray Cutter, as sole owner in fee simple, and that the chain of title from that deed ran in an unbroken line to me. Drop a comment, tell me where you're from, and if something like this has happened to you while you were away, I want to hear it. I did not get out of the truck right away. I sat there and looked at the bare rectangle of ground, and I told myself to be still. I had learned stillness in places where stillness was survival, and I brought it home with me the way you bring home a habit you cannot shed. I was not angry. I want to be clear about that. What I felt was something closer to the sensation of reading a document and finding a line that should not be there, a quiet, cold attention. Sandra Pruitt was still talking. I could see her mouth moving. I let her finish. Then I put the truck in reverse, drove back to the county road, and called a JAG officer I had served with named Captain Renata Ose. I told her what I had come home to. She was quiet for a moment, and then she said, "Don't touch anything. Don't move any of those boards. I want photographs before the weather changes." I took the photographs that afternoon, 47 of them, the pale rectangle, the scattered boards, the foundation stones my grandfather had set by hand in 1963, still present, still level, still carrying the memory of what had stood on them. I filed them by date and time, transferred them to a hard drive, and printed 12, which I placed in a manila envelope labeled in my grandfather's style, neat, unhurried, permanent. That was the beginning of the record. My grandfather's name was Eldon Ray Cutter, and he came to Calhoun County in 1947 with a discharge paper, a duffel bag, and $200 saved from his Army pay. He was 23 years old, the son of a Tennessee timberman, and he understood land the way some men understand engines, not as an abstraction, but as a system with its own logic and its own way of failing when you ignored what it was telling you. He bought 43 acres from a man named Horace Dunbar, whose sons had gone to the cities and had no intention of returning. The price was $1,100, paid in full, and the deed was recorded in Calhoun County on March 14, 1948. The land sat at the end of a gravel road that was, at the time, the only road in. There was a creek along the southern boundary, a stand of white oak along the north, and a slope of open pasture running east to west that caught the afternoon light in a way that made it look, on certain days in late summer, as though the ground itself were luminous. My grandfather built a house in 1951. He built the barn in 1963, the year my father was born. Framing it from timber, he cut himself from the white oak stand, curing the wood in the field for 8 months before he ever raised a wall. He told my father that a barn built from uncured wood was a barn built from a lie. He was not a man who used the word lie lightly. My father grew up on that land, learned to drive a tractor on it, learned to read a survey map, learned to repair a fence post in frozen ground. He took over the property in 1979 when my grandfather's health began to fail and ran it as a working farm for 20 years. Hay, a small cattle operation, and a timber lease along the western edge that brought in steady income without depleting the stand. My grandfather lived in the house until 2001, dying in February of that year at the age of 77 in the same bedroom where he had slept for 50 years. The land passed to my father by the terms of a will drawn up and recorded without ambiguity. I grew up in that house. I know the sound the screen door makes in a west wind, the smell of the barn in August when the heat had been in the wood all day, the particular silence that settles over the pasture just before dawn. I know where the creek floods in a wet spring. I know which fence posts my grandfather set himself and which ones my father replaced. I know the land, the way you know something you have touched every day of your life. I enlisted in 2009. My father was still managing the property, still living in the house, and I did not worry about it the way I might have if the land had been in uncertain hands. But he had a stroke in the spring of 2019, moved to a care facility in town, and the property sat quiet. The house sat quiet. I was in Afghanistan with a rifle and a rucksack and a deployment with no fixed end date. The barn sat quiet too, until it didn't. I did not know, while I was deployed, that Millhaven Estates had been developing the land to the east of my grandfather's property since 2015. I did not know that a subdivision had been platted along the county road, that a homeowners association had been incorporated, that covenants and restrictions had been recorded against the new lots. None of it had anything to do with my land. The Cutter parcel, 43 acres, recorded 1948, never subdivided, never annexed, never subjected to any covenant or restriction, sat entirely outside the Millhaven Estates plat. It was adjacent. It was not included. Those are two different things, and the difference is the entire story. What I also did not know was that Sandra Pruitt had been sending certified letters to the property address for 8 months. The letters went to my father's house, which was empty. They cited violations of community standards, the barn's condition, the appearance of the fence line along the eastern boundary, what she described in one letter as the visual impact of the structure on the community's aesthetic corridor. As if my grandfather's barn, which had stood on his land for 61 years, owed something to a subdivision incorporated 4 years ago. When the letters went unanswered, Sandra Pruitt did not consult a title attorney. She did not pull the plat map. She did not run a chain of title on the Cutter parcel. She hired a demolition contractor. The barn came down on a Tuesday in September. I was in Kandahar. I did not know until I landed at Fort Campbell 11 days later, drove the 2 hours to Calhoun County, and turned down the gravel road my grandfather had graded himself in 1952. The rectangle of pale earth was still there when Sandra Pruitt finished her speech about violations and compliance windows. She had a new letter for me, too, citing the remaining foundation stones as an eyesore, requesting their removal within 30 days. I took the letter. I thanked her for coming. She seemed slightly unsettled by the absence of reaction, the way people are unsettled when they expect a door to give and it does not. She walked back to her vehicle, white, clean, the kind that has never been asked to do real work, and I watched her drive back down the road. Then I called Renata Ose and told her about the new letter. "Good," Renata said. "Let her keep writing." The deed was in the house, in the bottom drawer of my grandfather's roll-top desk, in a manila envelope that had not been opened in years. I opened it that evening. 4 pages, typed on paper that had yellowed at the edges but remained legible in every particular. Eldon Ray Cutter, 43 acres, Calhoun County, March 14, 1948. Signed, witnessed, notarized, recorded at Book 12, page 447 of the Calhoun County Deed Records. I held it under the kitchen light and read every line, the way my grandfather had taught me to read a contract, not for what it said but for what it did not say, for the space between the words where the assumptions lived. There was no covenant, there was no restriction, there was no reference to any homeowners association, any community standard, any aesthetic corridor. There was land, and there was an owner, and the chain of title from that owner ran through my father and then to me, unbroken, unencumbered by anything Sandra Pruitt had ever put her name to. I photographed the deed and sent the photographs to Renata Ose at 11 o'clock that night. She responded at 11:14 with 4 words, "This is very clean." I put the deed back in the envelope back in the drawer. Then I sat at my grandfather's kitchen table, in the same chair where he had sat every morning of his adult life, and I listened to the silence of the property around me, and I thought about what Renata had said about patience and paper, and the particular kind of power that comes from holding something true in a drawer while someone else performs confidence they have not earned. The boards the demolition crew had left behind were still scattered at the edge of the bare rectangle, old-growth oak, my grandfather's timber, cut from his own stand and cured in his own field. I did not move them. I photographed each one with a tape measure laid alongside for scale. Some still had the original mortise cuts my grandfather had made by hand. You do not make mortise cuts in uncured wood. He had been right about that, the way he had been right about most things that mattered. I went to bed that night in my grandfather's house and slept without difficulty for the first time since I had landed. There is something clarifying about knowing exactly what you have and exactly what has been taken. The grief and the purpose arrive together, and they are not contradictory. They are the same thing, pointed in the same direction. The next morning, Renata Ose called at 7:15. She had already pulled the Calhoun County plat records online, had the Millhaven Estates recorded covenants open on her screen, and had the Cutter parcel deed beside them. She had one question. Did anyone ever contact you, in writing, formally, with your signature, asking you to subject this parcel to the Millhaven Estates covenants? No, I said. Did your father ever sign anything like that? Not that I know of. Did your grandfather? He's been dead since 2001. There was a pause. Then I need you to get me the full chain of title going back to 1948, certified copies from the county recorder, and every document Sandra Pruitt's association has ever recorded against your parcel number. I drove to the Calhoun County Recorder's office that morning. The office smelled of old paper and central heating and the particular institutional quiet of a place where the records outlast everyone who made them. I gave the clerk my parcel number, 14-0047-003, the same number assigned to my grandfather's land in 1948, and asked for certified copies of every recorded instrument against that parcel from original recording to present. The clerk was a woman named Darlene who had worked in that office for 22 years. She typed the number into her terminal, looked at the screen, and said, "Honey, there is nothing recorded against this parcel except the original deed and 2 routine tax filings. Nothing from Millhaven Estates HOA. She looked again. Not a thing. I asked her to print the full title history anyway, certified, with the recorder's seal. It was 6 pages. I paid $14 and stood at the counter and read every page before I left. Darlene watched me with the patient expression of someone who has seen people discover things at her counter before. The title history confirmed what the deed had already told me. The Cutter parcel had never been annexed into the Millhaven Estates plat. It had never been subjected to the Millhaven Estates Declaration of Covenants, Conditions, and Restrictions, which had been recorded in 2015 against a specific list of lots, none of which was parcel 14-0047-003. Sandra Pruitt's association had no recorded authority over my grandfather's land. Not a single instrument, not a single clause. She had sent 8 months of certified letters to a property she had no jurisdiction over, cited violations of standards that did not apply, and hired a contractor to demolish a barn on land she had no legal relationship with whatsoever. I folded the certified title history into the manila envelope with the deed photographs and drove back to my grandfather's house. A red-tailed hawk was working the fence line along the eastern boundary, riding the updraft off the pasture with the unhurried patience of something that understood exactly where it was and exactly what it owned. I sat in the truck for a moment and looked at all of it. Then I called Renata Ose and told her what Darlene had found. "Good," she said again. And this time there was something in her voice that was not quite satisfaction and not quite anticipation, but the same neighborhood as both. Renata drove down from Fort Campbell on a Thursday morning, arriving before I had finished my first cup of coffee. She wore a canvas jacket and carried a leather bag that looked like it had been through several continents, and she moved through my grandfather's kitchen with the deliberate ease of someone who had assessed rooms professionally for years. She set her bag on the table and began laying documents out in a sequence that told me she had been working since before I woke up. I want to walk you through what we have, she said, and then what we're going to do with it. I poured her coffee and sat across from her and listened. What Renata had assembled in 2 days was a file I would not have known how to build on my own, though I would have tried. She had pulled the Millhaven Estates Declaration of Covenants, Conditions, and Restrictions in full, 47 pages, recorded September 2015, with a complete exhibit listing every subject parcel. Parcel 14-0047-003 did not appear in that exhibit. She had also pulled the plat map as recorded, the association's articles of incorporation, and the contractor's license for the demolition company Sandra Pruitt had hired. She had the county building permit record, or rather its absence, because no demolition permit had been pulled for the work done on my grandfather's barn. That last item she set in front of me separately, with a small, deliberate motion, the way you place something on a table when you want the other person to understand its weight before you speak. No permit, I said. No permit, she said, which means the contractor performed unpermitted demolition work on a structure they had no legal authorization to touch, on land the party who hired them had no legal authority over. That is not a civil matter only. That is a criminal exposure question, and one the contractor's insurance carrier is going to find very interesting. She had already been in contact with a civil attorney she trusted, a man named Gerald Fitch, who had practiced property law in the county seat for 31 years. He had asked her 2 questions: whether the chain of title was clean and whether I had documentation of the structure's existence prior to demolition. She had told him yes to both, and he had said, "Then bring me the file and let's talk about wrongful demolition and trespass to chattels, because those boards were personal property." The boards. I had not thought of them in those terms, but Renata was right and Gerald Fitch was right. The timber my grandfather had cut from his own stand, cured in his own field, mortised by his own hands, and raised into a barn that had stood for 61 years. That timber was personal property, destroyed by a party with no legal right to touch it. I thought about my grandfather standing in the field in the summer of 1962, turning the curing boards by hand so the air could reach all 4 faces. He had done it every week for 8 months. He had told my father that patience was the only thing that separated a structure from a pile of wood. He had been talking about carpentry. He had also been talking about everything else. Gerald Fitch's office was on the 2nd floor of a building that had been a hardware store in a previous life, and the floors still had the solidity of a place built to hold weight. He was a compact, gray-haired man who wore reading glasses on a cord and had the habit of removing them while he spoke, as if they were a prop he used to measure the pace of a conversation. He shook my hand, looked at the file Renata had laid on his desk, and spent 12 minutes reading without speaking. When he finished, he set the file down and looked at me over his glasses. "Mr. Cutter," he said, "I want to make sure I understand the complete picture. The Millhaven Estates HOA sent certified letters to a property they had no recorded authority over, citing violations of covenants that do not apply to that property, and when those letters went unanswered, they hired a contractor who demolished a 61-year-old barn without a permit, without the owner's consent, and without any legal basis whatsoever." "That is correct," I said. He nodded slowly, the way a man nods when he is not surprised but is taking a moment to appreciate the full dimension of what he is looking at. "And you were deployed at the time?" "Yes." "And your father, the prior owner, was incapacitated in a care facility?" "Yes." He removed his glasses. "Then what we have is wrongful demolition of a permanent structure, trespass to real property, conversion of personal property, and potentially a violation of the Service Members' Civil Relief Act, depending on how we characterize the notice they attempted to give and the action they took while you were deployed and unable to respond." He looked at Renata. "You were thinking the same thing." "I was," she said. "The Service Members' Civil Relief Act. I had known the statute existed, but had not thought to apply it here." Renata explained it while Gerald Fitch listened with the patient expression of a man who already knew but appreciated hearing it stated clearly. The act placed specific restrictions on civil actions and proceedings against service members during active duty. designed precisely for situations in which a deployed soldier could not respond to legal processes or protect property interests. Sandra Pruitt had not simply overreached onto land she did not control. She had done it while the owner was deployed and had proceeded to a destructive action without making any effort to determine whether the property owner had legal protections that would have required her to stop. Whether she had known about my deployment was a question the record would answer. The certified letters were addressed to the property, not to me personally, at a verified address. She had not attempted to locate me. She had not contacted the Army. She had not determined whether the property owner was a service member on active duty. She had simply escalated on a schedule that suited her against a property she had no authority over while I was in Kandahar. Gerald Fitch drafted the initial demand letter that afternoon. I sat in his office while he dictated it, listening to the language accumulate. Precise, measured, each clause referencing a specific recorded instrument or statutory provision. The letter cited the Cutter Parcel Deed, Book 12, page 447, Calhoun County Deed Records, 1948. It cited the Millhaven Estates Declaration as recorded in 2015 and the specific exhibit listing subject parcels and the absence of parcel 14-0047-003 from that exhibit. It cited the absence of a demolition permit. It cited the Service Members Civil Relief Act, 50 U.S.C. Section 3901 ETCQ. It cited wrongful demolition, trespass, and conversion. It demanded a complete accounting of the contractor's work order, the board's authorization records, and all communications related to the Cutter parcel. It also demanded that the association preserve all records pending further legal proceedings. Gerald Fitch sent it by certified mail to Sandra Pruitt at the HOA address of record, and by separate certified mail to each of the 3 other board members named in the Articles of Incorporation. He sent a copy to the demolition contractor's registered address and to the contractor's insurance carrier. The letter went out on a Friday afternoon. I drove back to my grandfather's house in the early dark, the gravel road familiar under the truck tires. I made dinner in his kitchen and sat at his table and did not speculate about what would happen next. There was nothing useful in speculation. The record was assembled, the letter was sent, the paper was doing its work. What I did think about was the morning my grandfather had shown me the deed for the first time. I had been 11 years old. He had taken it from the bottom drawer of the roll-top desk and spread it on the kitchen table under the light, reading it to me not quickly, but the way you read something to a child when you want them to understand that the words have weight. He had pointed to his name, typed in the original instrument, and said, "That is your name too one day, and this paper is the reason no one can tell you different." I had not fully understood him then. I understood him now. The response to Gerald Fitch's demand letter arrived 11 days later, not from Sandra Pruitt directly, but from an attorney named Clifford Meade, counsel for the Millhaven Estates Homeowners Association. The letter was 4 pages, written in the dense defensive register of someone handed a bad set of facts and trying to build a wall around them with procedural language. Meade argued that the association had acted in good faith based on the property's adjacency to the community, that letters had been sent to the property address of record, that demolition had been undertaken as a maintenance action after prolonged non-response, and that the association's covenants were intended to apply to all properties within the community's sphere of influence. Sphere of influence. That was the phrase he used. Not the legal standard, which would have required a recorded instrument subjecting the parcel to the association's authority. Not a covenant. Not an easement. Not an annexation agreement. A sphere of influence which exists in geopolitics and in the imaginations of HOA board presidents, but which has no standing in a county deed record and no weight in a court of law. Gerald Fitch read the letter at his desk while I sat across from him. He read it twice. Then he set it down and looked at me over his glasses with an expression that was, for a man of his professional restraint, remarkably close to amusement. "They have confirmed," he said, "in writing, signed by their attorney, that they proceeded against your property based on adjacency and non-response, without any recorded legal authority. That is their defense." He paused. "It is not a defense. He drafted the response that afternoon, 2 pages. It cited every instrument Meade had failed to cite, noted the absence of any recorded authority over parcel 14-0047-003, noted the absence of a demolition permit, noted the Service Members' Civil Relief Act protections the association had failed to account for, and stated that any sphere of influence was a legal nullity unsupported by any recorded instrument in Calhoun County. The final paragraph stated that if the association did not respond within 30 days with a substantive legal basis for its claimed authority, a recorded instrument, a court order, or any legally cognizable document, the matter would proceed to formal action in Calhoun County Circuit Court. The 30 days passed. Clifford Meade sent one more letter, shorter than the first, restating the sphere of influence argument with minor variations. There was nothing new in it. No recorded instrument, no legal basis, only the assertion, made with diminishing confidence, that adjacency conferred authority. It did not. It never had. Gerald Fitch filed the complaint in Calhoun County Circuit Court on the 31st day. The case number was assigned that afternoon. Case number 2019-CV-00847, Cutter v. Millhaven Estates Homeowners Association et al. I wrote the number on the manila envelope where I kept the deed photographs and the certified title history. My grandfather had labeled everything neat, unhurried, permanent. I tried to do the same. The hearing was set for a Thursday in March, the kind of morning in Calhoun County where the cold has not yet decided whether to stay or go, and the light comes in low and pale across the pasture and makes the frost on the fence posts look like something deliberate. I drove the county road before dawn, sat in my grandfather's kitchen, drank coffee, and did not review the file. There was nothing left to review. Gerald Fitch had the file. Renata Osei had the file. The Calhoun County Circuit Court had the file. The record was complete, and there was nothing more I could add to it by reading it one more time in the dark. The courtroom was small, the way county courtrooms are small, wood-paneled, fluorescent-lit, smelling of old carpet, and the institutional patience of a room that has heard a great many arguments and rendered a great many judgments and has not been changed by any of them. I arrived 40 minutes early. Gerald Fitch came in at 8:40 with his leather bag and his banker's box, which he set on the plaintiff's table with the same deliberate care he brought to everything. Renata Osei sat beside me in the gallery with her own copy of the file in a folder on her lap. Sandra Pruitt arrived at 8:50 with Clifford Meade and 2 board members, Douglas Holt and Patricia Vance, who had both signed the authorization that preceded the demolition. They arranged themselves at the defense table with the careful composure of people who have been advised to appear calm and are working at it. Sandra Pruitt had a legal pad in front of her that she did not write on. Judge Harold Weston took the bench at 9 o'clock. He was a tall man with a deliberate manner and the habit of reading documents in open court without apology for the time it took. He had already reviewed the pleadings. He said so at the outset, and then said he had several questions for the defense and would like to begin there. What followed was not dramatic in the way courtroom scenes are dramatic in the imagination. There was no moment of revelation, no gasp from the gallery. There was only the judge and the record, and the growing silence at the defense table as Clifford Meade was asked, one by one, to produce the legal instruments that would support his client's claimed authority over parcel 14-0047-003. He could not produce them. There were none to produce. Judge Weston asked for the recorded instrument subjecting the Cutter parcel to the Millhaven Estates Declaration of Covenants, Conditions, and Restrictions. Meade cited the sphere of influence language from his earlier letter. Judge Weston looked at him over the bench with an expression of professional patience that contained somewhere in its depths the same quality I had seen in Darlene's face at the county recorder's counter, the expression of someone who has watched people discover things and has learned not to be surprised by what they find. He asked again for a recorded instrument. Meade said his client's position was that adjacency and community character created implied authority. Judge Weston said that implied authority was not a recorded instrument and asked again. There was no recorded instrument. The judge noted this for the record. He then asked for the demolition permit. Meade said his client had understood the action to fall within the association's maintenance authority. Judge Weston asked for the permit. Meade said there was no permit. The judge noted this as well. Gerald Fitch presented our case in 40 minutes. He introduced the Cutter parcel deed, Book 12, page 447, Calhoun County Deed Records, 1948, certified copy, recorder's seal. He introduced the certified title history, showing no recorded instrument from Millhaven Estates against parcel 14-00-47003. He introduced the Millhaven Estates Declaration as recorded in 2015, with the exhibit of subject parcels, and noted that parcel 14-00-47003 did not appear in that exhibit or anywhere in the document. He introduced the absence of a demolition permit. He introduced the certified mail records showing that letters had been sent to a property whose owner was on active military deployment, along with my deployment orders. He introduced the relevant provisions of the Service Members Civil Relief Act, 50 U.S.C., Section 3901 et seq., which required any party seeking to take action affecting a service member's property interests to first determine whether the owner was on active duty and to apply to a court for a stay of proceedings if so. The association had done neither. He introduced the photographs. The barn, as it had stood, a photograph taken in the summer of 2017, the structure still whole, the white oak timber still carrying its grain, the foundation stones still level beneath it, the rectangle of pale earth as I had found it 11 days after landing at Fort Campbell, the scattered boards, each measured, each documented, the mortise cuts my grandfather had made by hand in 1962. Judge Weston looked at the photographs for a long time. Renata Osei, sitting beside me in the gallery, did not move. I was not angry. I want to be clear about that, even now. What I felt in that courtroom was something closer to what my grandfather had described when he talked about the moment a timber frame comes true, when the last peg is driven and the structure settles into itself and you know, without measuring again, that it is right. The record had come true. The paper had done its work. Judge Weston issued his ruling from the bench that afternoon. He found that the Millhaven Estates Homeowners Association had no recorded legal authority over parcel 14-0047-003 and had never possessed any such authority. He found that the demolition had been conducted without legal authorization, without a required permit, and without compliance with the Service Members Civil Relief Act. He found that the association and its board, specifically Sandra Pruitt as president, Douglas Holt, and Patricia Vance as authorizing members, had committed wrongful demolition of a permanent structure, trespass to real property, and conversion of personal property. He awarded compensatory damages of $68,000, established through a structural assessment of the barn's replacement value and a timber appraisal of the destroyed old-growth white oak. He awarded attorney's fees. He awarded statutory damages under the Service Members Civil Relief Act. He referred the matter of the unpermitted demolition to the County Building Authority for action against the contractor's license. The total judgment was $114,000. He also issued a permanent injunction barring the Millhaven Estates Homeowners Association from asserting any authority, sending any communication, or taking any action with respect to parcel 14-0047-003 in perpetuity, recorded against the association's own articles of incorporation in the Calhoun County records. Sandra Pruitt did not look at me when it was over. She gathered her legal pad, still blank, and walked out with Clifford Meade beside her. I watched her go and felt nothing toward her that resembled triumph. What I felt was the same thing I had felt reading the deed under the kitchen light on the first night, a quiet, cold clarity. The record had said what it said. The court had read the record. That was all. Gerald Fitch shook my hand at the plaintiff's table, and Renata Osei shook my hand in the corridor, and neither said very much, because there was not very much that needed saying. The file had spoken. We had only carried it. The judgment was paid in full 4 months later, drawn from the association's reserve fund and, when that proved insufficient, from a special assessment levied against the Millhaven Estates lots. Sandra Pruitt resigned from the board the following week. Douglas Holt and Patricia Vance resigned the week after that. The Millhaven Estates Homeowners Association held a special election and seated a new board, whose first recorded action was a formal resolution acknowledging that parcel 14-0047-003 was not subject to the association's authority and had never been. They recorded that resolution in Calhoun County. It is in the record now, permanently, alongside the deed and the title history and the injunction, a document that will outlast everyone who signed it. I drove home from Gerald Fitch's office on the afternoon I received his letter confirming payment. The gravel road was dry, the way it gets in July when the heat has been in the ground for weeks, and the dust rose behind the truck the way it always had, the way it had risen behind my grandfather's truck and my father's truck on this same road for 70 years. The pasture was full of summer, the grass long and pale gold in the afternoon light. The white oaks stand along the north boundary dense and dark green, the creek along the south running low but present, threading through the willows with the patient sound of water that knows it is not going anywhere. A pair of mallards lifted from the shallows as I came down the slope, their wings catching the light for a moment before they settled again downstream. The foundation stones were still there. I had not moved them. I did not intend to move them. They were my grandfather's work, set by his hands in 1963, and they were level, and they were true, and they marked the place where something had stood and where something would stand again. I had spoken with a timber framer in the spring who had looked at the mortise cuts in the surviving boards with quiet respect. He said the wood was still sound. He said old-growth white oak, properly cured, did not give up easily. He said we could use what remained. I stood at the edge of the foundation that evening and looked at the stones and the pasture and the light coming down across the slope. And I thought about what my grandfather had said when he showed me the deed for the first time, that the paper was the reason no one could tell you different. He had been right. He had always been right about the things that mattered. The paper had held. The record had held. The land had held. There is a thing I have come to understand about authority, not authority earned, but authority performed. The kind that arrives in a blazer on a gravel road and speaks in the grammar of certainty without having checked whether the certainty has a foundation. When an institution with apparent power makes a claim against you, the first question is not whether to comply. The first question is whether the claim has a legal basis, not an implied basis, not a sphere of influence, a recorded instrument, a court order, a document that exists in the public record and can be read by anyone who knows where to look. That question has an answer. The answer is always in the record, and the record, if you have kept it carefully, if you have photographed what was there before it was gone, filed what needed to be filed, and let the paper do the work that paper is designed to do, the record will carry you. It carried my grandfather's name for 70 years. It carried mine. The mallards came back to the creek at dusk, settling into the shallows with the unhurried certainty of creatures that understood exactly where they were. The foundation stones caught the last light. The old boards lay stacked at the field's edge, sound and waiting. The gravel road ran quiet behind me, the same road my grandfather had graded himself in 1952. And the same road Sandra Pruitt had driven in on with her clipboard and her 14-day compliance window and her confidence in an authority she had never thought to verify. The road was mine. It had always been mine. If you have a story about land, a boundary line, a deed someone told you did not mean what it said, I would genuinely like to hear it in the comments. And if you want to follow the next case, which involves a different kind of recorded instrument and a different kind of overreach, the subscribe button is there, and it is quiet, the way everything on this channel tries to be.